We dismiss history at our peril.
Liberty Nation Radio with Mark Angelides.
Race-based discrimination is on the chopping block at the Supreme Court, as not one, but two major cases are set to be heard. Will the justices rule that academic ability alone should be the deciding factor in college admissions, or will affirmative action continue unabated? Welcome back to Liberty Nation Radio here on the Radio American Network. I'm your host, Mark Angelides. We have a special Affirmative Action at SCOTUS edition for you today, examining the cases, the impact, and the implications. I want to take a moment to say a special thank you to our listeners out in Great Falls, Montana on KQDI 1450 AM and 97.5 FM. Thanks for taking the time to tune in. And remember, this show is proudly sponsored by LibertyNation.com, where you can access podcasts, breaking news, analysis, and a range of biting and brilliant shows to whet your appetite for freedom and your fondness for the great American Constitution. All eyes are on the Supreme Court and the affirmative action cases that are landing this week. Now, what are the arguments? What are the ramifications? Well, we're lucky to have with us someone who has been watching these cases develop and has delved into the pits to find the answers. We welcome aboard for our Liberty Nation Radio Special Edition, host of the Uprising podcast, constitutional attorney, LN's legal affairs editor, and a man who, despite not being a beneficiary of affirmative action, is still willing to talk about it. Mr. Scott D. Cosenza, Esquire, welcome aboard.
Thank you, Mark. Not just yet, anyway. I am pining for the days when I get in on something on the basis of my immutable characteristics rather than my charm and
charm and good looks. It swings and roundabouts, Scott. What goes around comes around. So what we're seeing here at the Supreme Court, Scott, is there's actually, I believe you explained this to us last week, but maybe if you could do a brief recap. There are two cases that are sort of coming together and then separating, and they both deal with the long-standing affirmative action issue. So can you tell us what the cases are, why they're being pushed together and pulled apart, and what the arguments will be?
So I think that we shouldn't spend too much time on there's two cases and they're pushed together and pulled apart. That has to do with Ketanji Brown Jackson, the latest addition to the Supreme Court. Justice Jackson was on a Harvard committee, and because of that, she has a conflict of interest. And so the two cases which concerned the Harvard College and the University of North Carolina were split up so they could be argued separately so that Justice Jackson could sit in on the North Carolina case and not on the Harvard case, where, again, she has a conflict because she was on some board. I don't think anybody really in the legal community, Mark, thinks that Justice Jackson would rule any differently based on her. She either thinks affirmative action's okay or not.
Of course, Scott. The opposite here is that if it were, let's say, for example, Justice Clarence Thomas, they would be demanding that he not only recuse himself, but resign from position and get another 7 justices appointed by President Biden, yes?
I think his wife once drove in Massachusetts, which I think they say disqualifies him.
It's clearly an impeachable offense. I'd say that for anybody, in fact, who drives in Massachusetts. Not obviously no insult meant to our Massachusetts listeners.
So the only reason why this whole thing about the two cases might come into play is we could, at the back end of this, in presumably the springtime, when a decision or the new year, when I would expect a decision in this case to be announced, that we may get some nuance in the case. When we talk about the history of this, the affirmative action of the Supreme Court has actually already in the past been marked by kind of an oddity based on justice counts because of Justice Scalia's death and a recusal. Justice Kagan recused herself from a Harvard case some time ago. But sufficient time
to dive into here, Scott.
Sufficient time has passed for Kagan, by the way, that she thinks that conflict is over. So she is going to be a part of it.
So she thinks it's over, but of course, because it's the Supreme Court and should rightly not be beholden to any other branch of government here, it's her decision whether to recuse herself or not, correct?
It's always the justice's decision to recuse themselves or not. Absolutely.
I find that's interesting, especially seeing as so many calls are about for other justices to recuse themselves from certain cases in the media. But that's a completely different topic, which we'll come to at some point in our Liberty Nation Radio future.
I think that those calls, Mark, generally come from political circles rather than legal ones. I don't see much in the way of the legal community up in arms that Justice Thomas is ruling on X, Y, or Z, or Justice Kagan might be. We realize that being on the booster committee for Harvard is probably unlikely to sway one's core holding in a landmark case such as this.
So what are the arguments going forward then? And clearly, we'll talk about the implications later on in the show, Scott. But is affirmative action literally on the chopping block with these cases?
In both cases, the first question that the court has said they will consider is whether the court should overrule its previous holdings that allow higher education institutions to use race as a factor in admissions. So the answer is a resounding yes, Mark, which is what has driven the massive interest in this case. And it is massive, to say the least.
Well, it's a complete reworking of the American educational system for a start. And then, of course, there are other things which our listeners will have to stay tuned for to figure out the final implications as we go along in the show.
Now, the final implication sounds quite ominous.
That does sound very ominous. That's not quite my meaning. The other implications that we may be discussing later on in the show, it is well worth hanging on for, and it's not as ominous as Scott DeCosenza makes it out to be. So what's the second question from the other case, Scott?
So there are two other questions, and they basically involve whether or not, the first is whether or not the Civil Rights Act, Title VI, basically, can they discriminate against Asians in a balancing and overrepresentation of blacks? Are they allowed to kind of discriminate against Asians? That's one of the other questions. And the third question is whether or not they can reject a substitute plan that's race neutral because they don't like the outcome. So there are many, many ways that Harvard could presumably use a non-race based system to achieve racial diversity. So for instance, Mark, it's been proposed that they use zip codes. So if you use a zip code that's heavily populated by African Americans compared to whites and prefer candidates from that zip code, would that be constitutional to impose plans that don't directly consider race, but get at race through a kind of oblique angle, if you will?
I think that there might be some issues with that particular approach, like, for example, the zip code approach, because a wealthy family might rent a beaten up old apartment for $300 a month in a bad area of the city, and then just claim that as, well, this is my child's predominant housing location, and therefore they could increase their chance that way. It's kind of open to
well, I would just say, firstly, that
fraud,
let's not say might. Certainly, people will game whatever system is employed. But more importantly than that, I think in terms of the legal analysis that the court will undertake, Mark, is if it's impermissible, if the court rules that it's impermissible to use race as a basis for admission, then getting at race through circular measures would presumably be, or potentially be, illegal as well. So if you can discriminate against black people, for instance, by preferring certain zip codes, then could you discriminate for black people by preferring certain zip codes? If race is an impermissible factor, the answer must be no, I think, to be consistent.
Okay, and this isn't just going to apply to Harvard, though, is it? I mean, the case is about Harvard, but this applies to...
about Harvard. The case is about University of North Carolina and the use of race in higher education. But the lower education, if you will, secondary and elementary school, they take their guidance from this as well. This is about the American educational system, firstly, and then even much more broad than that. Businesses take their cues from these things. The Department of Justice, when they decide who to prosecute and how for racial discrimination, takes their cues from these court rulings. So this is, Mark, I think that the level of interest that we see by the overwhelming number of amicus briefs filed in the case, for instance, is justified by the potential scope of what the past rulings have shown and what a reversal could show in this case.
Okay, now later on in the show, we're going to be talking about the indications, what people are thinking, and the implications, how this will change the very face of America. We're talking with Scott DeCosenza, and we'll be right back after this short break. Don't go anywhere. We dismiss history at our peril.
Liberty Nation Radio with Mark Angelides. Entertaining, informative, and just plain fun. Watch Liberty Nation's The Conservative Five, produced by conservatives for conservatives. C5's The Left Free Zone, hosted by Liberty Nation's Lisa K. Donner, joined by a raucous, irreverent panel of authors, deconstructing leftist narratives, debating the hot topics, and remembering to laugh. Join the official conservative safe
You only
space.
did that to piss Jeff off.
Liberty Nation's The Conservative Five.